morning. Be seated, please. We have three cases on our calendar for this morning. We'll hear the cases in the order in which they appear on the calendar. The first case is Russell versus the Agency for Persons with Disabilities. Is counsel for the appellant ready to proceed? Please come forward.
May it please the Court. My name is Paolo Anino, and today I'm speaking for Amber Russell, and my co-counsel is Mary Clark. We wish to reserve 5 minutes.
All right.
We are here today on the legal issue of whether or not Amber Russell meets the legal requirement for crisis status under Medicaid law. But before I get to that issue of the legal issue of crisis, I wish to bring out a dispositive fact, a fact that resolves this case in many ways. This dispositive fact is that it is undisputed that Amber Russell is a danger to herself and others. Amber, let me just talk about her for a moment.
When you say that that question is undisputed,
yes,
now, is there a finding in the order that she is a danger to herself or others?
Your Honor, there is, in the order itself, there is, the hearing officer went over the criteria for Medicaid waiver crisis. And there's this specific criteria dealing with for danger to herself and others. The hearing officer never used the language that she was a danger to herself and others, but I think a fair and reasonable reading.
Well, now the hearing officer made reference to testimony that would support such a finding.
Yes, Your Honor.
But I didn't, in reading the order, understand that the hearing officer made that ultimate finding as to whether or not she was a danger to herself or others. Maybe I overlooked that. That was the reason for the question.
Well, Your Honor, I think when the hearing officer went through the different standards for danger to herself and others, I refer you to page 16 of the final order. Page 16 of the final order, the hearing officer is referring to the criteria, and she states, it appears the individual or others are at high risk for serious injury or permanent damage. It appears that the individual or others are at high risk for serious injury or permanent damage. And then the hearing officer responds, the testimony included numerous instances of running away which could result in serious injury or permanent damage.
So you think that finding is implicit in that? That's
yes, Your Honor. And given the fact that there was no witness, from either side that made any statement that she was not in danger to herself or others.
Well, now, aren't there three basic criteria for this crisis determination?
Yes.
And that's one of them. And another is homelessness. And,
yes,
and there's no assertion that this young lady is homeless.
No, Amber is not homeless, Your Honor. The way it works is there's a crisis identification tool. And the crisis identification tool is an instrument created by DCF to identify those developmentally disabled individuals who meet the crisis standard. And there's three ways of meeting it. And it's disjunctive, or. Either you're a danger to yourself or others, or you're homeless, or your caretaker can no longer take care of you. So your position is that if any of the three are satisfied, then there's a requirement of this crisis designation? Yes, Your Honor. That's exactly our position.
Now, didn't the hearing officer here find that the determination of the fact that petitioner was not in crisis was based primarily on the fact that petitioner was a participant in the foster care program and that program had the responsibility to meet her needs?
Yes. DCF's basic argument is the argument adopted by the hearing officer. And that basic argument is that, yes, and the hearing is interesting, the hearing officer specifically states in her order that Amber requires excessive in services in excess of what plain Medicaid can provide. So there's no dispute that she needs services more than regular Medicaid can provide. That's not in dispute. What the hearing officer, agreeing with DCF, stated, well, the foster care system can provide it. And that's their primary argument. There's two reasons why that argument doesn't work. The primary reason is this program is an optional program. Medicaid waivers are an optional program. But once the state decides to adopt this program, they're circumscribed by rules. And one specific rule is a federal rule dealing with third-party liability, and that's 42 CFR 433.139 parentheses C, 42 CFR 433.139 parentheses C, and that's cited in our brief. And that rule states that there's only a liable third party is when that third party is available. That's the key word, available to provide the services. If that third party is not available, then that's not a liable third party. And what we did in this case, Your Honor, all the witnesses testified that DCF was not available to provide a service. We had Kelly Bennett. Kelly Bennett is a guardian ad litem. She was doing it for 13 years. At one time, she worked for DCF as a dependency attorney, representing DCF. She represented Amber, and Kelly testified that DCF has not provided the services that the child needs, and not only has not, but cannot.
What is the waiver program going to provide by way of services that she's not getting already in the foster care program?
Yes, Your Honor. If I may just step back for a moment, though, and answer that question, it simply is the difference between Medicaid and Medicaid waiver. In the foster care program, she receives Medicaid services. And Medicaid services is a national health insurance program for the poor, children, elderly, and disabled. And so doctor visits would be paid for by Medicaid, a variety of rehabilitation. When we talk about Medicaid, we're always emphasizing rehabilitation. Medicaid waiver is a little shift. Instead of emphasizing rehabilitation or doctor visits, Medicaid waiver emphasizes habilitation, services that help a person get by in life, to be independent. So specifically, to answer your question now, the services she needs are behavioral services, intensive behavioral services. She also needs, and this was requested initially when Amanda Jones, who worked for DCF as their foster care caseworker, requested a Medicaid waiver. And then the services that were requested were behavioral services, non-residential support services, and the third were companion services.
But Dr. Blandino stated that she really needs residential care. Is this going under the waiver program? If she gets this crisis status that you're seeking,
yes,
is that going to provide her residential care? It's not, is it?
Well, the answer is it does indirectly. It's interesting how this works. The Medicaid waiver will not pay for residential care.
That's what the purpose of that is, to try to avoid institutionalization, right?
Institutional residential care. But it will be able to provide care for her in a group home. And that's where, it's one of the possibilities here. In this case,
but she's been through that process. So what I'm struggling with is, what does this crisis status that you're seeking, what is that going to provide her that she doesn't already have?
I think if I may turn to Kelly Bennett again, because I think Kelly Bennett in her testimony, or Amanda Jones, if I may on that. Amanda Jones was the foster care caseworker, and she was asked that question in so many ways. You know, what is this going to provide Amber? And if I just turn that for a second and see what Amanda says. Amanda says, Ms. Jones, she says, she needs, and this is on 116 of the record, she needs to have intensive individual therapy on a daily basis. We just were unable to provide that. Again, a Medicaid waiver, because it's a super Medicaid or a Medicaid plus, can provide that type of psychiatric services, can provide intensive behavioral services for her.
So she may be in the same type of group home, but have more services provided
Absolutely.
by medical professionals that come to the home.
And where we have evidence in this case that she does need behavioral services, Developmental Disability Division also acknowledged that, and that's what she would be able to obtain in this case.
When this term unable is used by Ms.
Yes.
Jones, does she mean that in the sense that we don't have resources to do it, or does she mean it in the sense that as a matter of law, Medicaid without waiver cannot provide these services? It's not allowed legally to provide the services.
Ms. Jones directly addressed that. She states on record 115, and she's a representative of DCF now. That's very important. I mean, DCF privatized the foster care system, so now that Children's Home Society is the actual provider. So she now works for Children's Home Society, but Ms. Jones states, we don't have the funding to take care of her. So the answer to your question directly is funding. The Children's Home Society simply does not have the funding to provide her the intensive psychiatric services, the intensive psychological services, the behavioral services, and the companion services that she needs.
But it would not be contrary to law for them to provide the services without the waiver if they had sufficient resources.
It would not be contrary to law, Your Honor.
Was Ms. Jones' testimony the only testimony going to the sufficiency of resources in the current setting to accomplish what this appellant needs?
Also, Ms. Kelly Bennett, the guardian ad litem, she also talks about why the foster care system simply cannot provide these services for Amber. What Kelly Bennett states is that the complexity of Amber's disabilities, that Amber is a child. When she was denied a crisis status, she was 12 years old. Parental rights were terminated from her parents in November 2001. They were terminated because of physical, sexual, and abandonment. During that time frame, and Amber has a variety of disabilities. She has psychiatric disabilities, psychological disabilities, emotional disabilities, and she's developmentally delayed. And given that complexity of her disabilities, Kelly Bennett's answer was that she did not see how the foster care system can provide her services that she needs.
Was there any other testimony other than Ms. Bennett's testimony, Ms. Jones' testimony going to that question?
No, Your Honor, not to my knowledge.
Who had the burden of proof so far as establishing whether or not there were sufficient resources?
We accept the Ellingham case, the first district court of a case in Ellingham. In Ellingham, the first DCA has held that the burden of proof when it comes to funding, and Ellingham was a case where there was no dispute that the person needed developmental services. But the department said in Ellingham, we simply don't have the funding for it. And in Ellingham, the court said that the burden is on the department to show that they do not have the funding. In this case, we showed that the department, DCF, is not available to provide the services. There was no one to rebut that. And DCF simply has not met the burden to show that they could provide it. They could have had a witness there from DCF saying, oh, yes, we can provide these services, but they didn't.
But again, though, the hearing officer did not make a specific factual finding on that question, did she?
She found that, let me try to understand the question. She found that family services or family safety should provide the services.
But that's not the same as the question of whether or not there are sufficient resources for this to be provided without the waiver.
No, she did not go through that, Your Honor.
Counsel, we're not really talking about whether these services will be provided. Isn't the issue here whether this appellant is in crisis and will be put in the front of a waiting list?
Yes, the way it works is, we are talking about, in reality, we are talking about whether or not the services are going to be provided.
Well,
but they haven't been provided as of the time of the
hearing. But it's still subject to there being sufficient resources so that these services can be paid for. And so and she's simply higher up on the waiting list by being determined to be in crisis. I'm just trying to understand how it works.
There's two waiting lists in the regulations. There's the regular waiting list, and right now, when Amber was denied crisis status, she was 14,182 on the waiting list, the regular waiting list. 14,182. So there's 14,181 people ahead of her. The only way, as a practical matter, that she's ever going to get these intensive services that she needs is if she gets placed on the crisis waiting list. What the crisis waiting list is those developmentally delayed individuals who are either in danger themselves, homeless, or the caretakers can't take them, and they're placed on the crisis waiting list, which bumps them up in front of the thousands of others. Your Honor, the second argument, besides that DCF is available, besides that DCF is not available to provide the services, and I think we proved that at the hearing. The second argument is simply there is no third party here. Where is the liable third party? We have DCF who runs the Medicaid application system. We have Amber Russell, who's the applicant, and then you have DCF who takes care of the foster care system. So we don't have a third party. We have DCF twice, and now is the Agency for Persons with Disabilities. But still, what we have is Amber Russell and the state of Florida. We don't have a liable third person where Medicaid division can sue itself. There's no third party where you can sue here. So even if, so this court should simply find for two reasons, simply that foster care simply is not available to provide the services, they didn't provide the services, and there's no evidence they can provide the service. And second is, there's no third party here anyway that's liable. Because foster care can't sue itself. DCF, at least in the state of Florida, we don't have agencies suing other agencies.
You're into your rebuttal time.
Thank you, Your Honor.
Reserve that. Yes, sir.
May it please the Court, opposing counsel. Good morning. My name is Eric Sugar. I'm an attorney for the Department of Children and Families, here representing the Agency for Persons with Disabilities, and I'm going to request that you affirm the decision of the Department's hearing officer below. I think Judge Van Nortwick has the issue correct, that in this case, the issue is the factual determination by the hearing officer that this appellant is not in crisis as defined by the waiver. The waiver was previously administered by the Department of Children and Families, but it was transferred to the Agency for Persons with Disabilities by a session law in 2004, which is cited in my brief. I think it may be cited as a Chapter 2005 session law, but that would be incorrect. There was a prior hearing on this matter, a prior appeal from a prior order and a remand in Russell v. DCF, which is at 910 Southern 2nd 881. I think implicit in the court's ruling at that time was the direction to the agency that this is a factual determination, because the court directed the hearing officer to re-examine the 13 crisis criteria, second priority crisis criteria. For reasons that I'll discuss later, the hearing officer correctly ruled that those aren't applicable to this case, because the real meat of the coconut, if you will, is whether or not she's in crisis to begin with.
Is it the agency's position that foster children in the state of Florida are not entitled to the Medicaid waiver program?
No. They are entitled to the Medicaid program. They get general state plan Medicaid, but to get the waiver, Judge Polston, as you've noted, one of the criteria is whether or not they're getting services. And I think you previously identified one of the key issues, that she's getting the services that she needs. At the time of the hearing in this matter, she was at Tall Pines Family Care Center, or a facility with a similar name, in Crestview, which is in Okaloosa County, Florida. I've been advised that since the briefs on this matter, the most recent briefs at the end of last year, that she's been returned to her biological father through the dependency court.
But counsel, what is the evidence in the record that supports a finding? First of all, where is there a finding that her needs are being met?
Well, Judge, I think it's implicit in the hearing officer's order that her needs are being met.
The hearing officer basically affirms the finding that she's not in crisis based on the fact that the foster care program has the responsibility to meet her needs. Now, that seems to, if that's the finding, then that seems to me, and I go back to Judge Polston's question, a finding that says if you're in foster care, as a matter of law, you cannot be found to be in crisis?
Well, Judge, I think the best way I can answer that question is directly as possible, is to say there are many stakeholders in this whole deal, and I'll talk about those in a minute. But to answer your question directly, it would be somewhat incongruous for the state, on the one hand, to remove a child from her family and start to take care of that child through the family safety program of the Department of Children and Families. Then, on the other hand, say, well, even though we've removed you, you're in crisis through the DCF DD program, which is now the Agency for Persons with Disabilities, to make them eligible for waiver. I think there was testimony in the record by both Mary Ann Ferlazzo from the central office, which is now the central office of the Agency for Persons with Disabilities, and Willie Davis, the program operations administrator for the area 1 with the APD, that the agency is not at liberty to add people because they believe the services they're getting from some other source are insufficient to meet their needs.
Well, and then we're back to, I think, Judge Polston's question. It seems to me what the agency is saying is if we have them in foster care, they can't be in crisis to receive these services. I think that's what you just said in so many words.
Well, Judge, I think that there's a difference of opinion on the matter, on this factual issue, and it was resolved in favor of the agency twice.
But that's my question. I'm not sure I find a finding that says the needs of the appellant are being met or even can be met by the foster care system.
I think that deciding whether or not her needs are being met by the foster care system somewhat puts the cart before the horse in this case. The first issue that has to be decided is whether or not she's in crisis. Remember, she was waitlisted for the waiver, which, as the letter that's in the record indicates, is not a guarantee of eligibility, but you're essentially told one of three things: yes, no, or wait. She was told wait. There's not available funding.
Well, is there any evidence in the record from which a finder of fact could conclude that that Ms. Russell is not exhibiting behaviors that result in harm to her or others? Is there any evidence in the record that says she is not exhibiting that type of behavior?
Well, Judge, I think there was evidence in the record that she did exhibit problematic behaviors, but they were addressed. They were addressed symptomatically in the way that's available to the state to address them, and that's through Baker Act placements under Chapter 394.
But isn't that begging the question? Isn't the issue here is whether she gets these additional services that are not currently available, if I understand the record and the law, that are not currently available? And therefore, and the record, it seems to me, doesn't have any evidence to say that other than Baker acting her occasionally or frequently, that there are any services being provided on a professional level that may prevent these behaviors.
Well, Judge, I think that, to continue my prior point to answer your question is, Baker Act services for people who are acutely mentally ill are provided under Chapter 394. These services that we're talking about, Medicaid waiver, are provided under Chapter 393. It's a different panoply of services. The handbook covers the things that were sought, such as residential placement, non-residential support services, and companion. Companion being someone who takes you for training activities in the community. That's not the delivery of mental health services. Again, I think that it boils down to there's a difference of opinion about what this child needs. The state's position, the state can't take a position that's contrary to itself. It looks schizophrenic. So the state's position is that the Department of Children and Families, through its family safety programs, is providing adequate services. The testimony of Amanda Jones, who is a contract service provider, on direct examination to the contrary, when I inquired of her on cross-examination, she acknowledged that her agency, Children's Home Society, I believe it is, in Leon County, Florida, is a community-based care provider pursuant to a provision in Chapter 409 that's cited in my brief, and they're paid. They are paid money by the Department of Children and Families to provide necessary services to children taken into foster care. So, Judge, it is their responsibility. Now, a disagreement as to whether or not the services they're providing are adequate must be addressed through the dependency court in the circuit court in Leon County.
But isn't that what this whole question of whether she's in crisis is all about?
I don't believe it is, Judge. I think that the sufficiency of the resources, if you want to talk about whether the Agency for Persons with Disabilities has sufficient resources to place this applicant on the waiver or in crisis, that might be a proper inquiry. But to inquire in this case regarding the Agency for Persons with Disabilities and the Medicaid Developmental Disabilities Home and Community-Based Services waiver, whether the agency has adequate funding, it really is getting too far afield from the core issue.
Is it adequate funding, or is crisis? Excuse me. Is it adequate funding, or is the question whether they have available services and they're being provided? It seems to me the record here is replete with facts that show that the needed services are not being provided to this appellant, except for the fact that when she acts suicidal or like she will harm others, she's Baker acted.
Judge, as I've said, the state, I don't believe I in good faith can make the argument to you that she doesn't need help. She needs help.
Beyond what the foster care program is providing.
I don't believe beyond what the foster care is providing.
Well, isn't it unrebutted evidence in the record from everyone having to do with the foster care program that this foster program cannot get to her what she needs to get by way of services?
Judge, I believe that's an accurate characterization of the guardian ad litem appointed by the court in the dependency case, and Amanda Jones, who was the foster care worker contracted through Children's Home Society. The testimony of the witnesses adduced by the agency, then the department DD program, was that she wasn't in crisis as they look at it as defined under the Medicaid waiver. And as I said, there are many stakeholders in this issue. You got the Agency for Healthcare Administration, who is the single designated state agency. Their rules authorize the Medicaid waiver and adopt the handbook that's at issue here. You've got the Department of Children and Families running the foster care program and formally running the waiver through its developmental disabilities program. Then you've got the Agency for Persons with Disabilities being carved out of the department, made its own agency. You've got the hearing officer, who is from DCF. You got the general master for the circuit court in Leon County essentially presiding over the dependency case under the supervision of a circuit judge. And then you have her appointed representatives
Is this a question of bureaucratic jurisdiction? Are we caught up where DCF has bifurcated these services, and it's where the two agencies providing services come together? We can't seem to coordinate?
No, Judge, I don't think that's the case at all. And in fact, as I've told you, it would be schizophrenic for the agency to or the state to internally assert positions contrary to itself. I think the issue really boils down to...
I wish you'd explain that in more detail. I'm not sure I understand, because as I interpret what you just said, it is that the agency over the family safety program, that's, as I understand it, a part of the foster care system, can't acknowledge they can't provide necessary services so that a petitioner might fit under the Medicare waiver.
I just don't think that's true, Judge.
I'm not saying that's true. I'm saying, is that what you're saying? Is that what I'm trying to understand what you're telling me when you say it's schizophrenic.
Here's what I'm telling you.
Schizophrenic for the state to do something.
Here's what I'm telling you. As an attorney for the state representing the department, which at the time of this hearing had both of these services, it doesn't do for me to call witnesses from the family safety program to talk about the adequacy of their program. They provide the services they provide. That information is communicated to what's now the Agency for Persons with Disabilities. They look at the application, say, you may be eligible. We believe you're eligible. You're put on a wait list. Then a crisis application is made. The agency looks at that and says, well, you're not in crisis. You're being served. You're being served. You have foster care services, you have state plan Medicaid, and you have services from the Department of Education. I believe the hearing officer makes that finding twice in the final order.
Is this determination reached through use of this crisis identification tool, or is it done outside the crisis identification tool, or what?
There's the crisis identification tool, Judge, and then there are attachments to the tool.
Well, you know, does the department challenge what has been suggested to be the implicit finding of the hearing officer here that this young woman is a danger to herself or others?
I don't think that's the implicit finding. I think the finding is that she's not in crisis.
Well, I'm not talking about that. I mean, there are three elements here, and I'm talking about the first element, which is whether or not she's a danger to herself or others. Now, she's been Baker Acted several times, which that, of course, is a threshold requirement for that. But the department challenges the fact that she's a danger to herself or others. Is that what you're saying?
Judge, I can't say that that's the case because I know that the hearing officer addressed the 13 criteria as directed by this court, but addressed them with the view of those are 13 criteria that have to be examined once an applicant's determined to be in crisis. And here again,
what I really want is a yes or a no. Does the department challenge the apparent finding that this woman is a danger to herself or others? A yes or no would be fine. That's all I really want.
Judge, I don't recall any evidence in the record that the agency's representative said she's not a danger to herself or others.
Okay.
And to give you a yes or no, I'll say no. The agency doesn't challenge that she's exhibited those behaviors.
Okay.
I just don't think that the agency can logically take that position, much as the agency can't logically take the position that the other branch of the state, which was essentially part of it, part of the department at the time of this hearing, isn't doing its job. The position is, hey, the state is doing its job with respect to this child.
Okay, well, I'm getting to another criteria. We know she's not homeless. Everyone agrees she's not homeless.
Right.
Now, when going to the business about the state's already doing its job, is that tied into this third criteria here on this crisis identification tool, caregiver unable to give care?
Judge, I think to an extent it is.
Does that relate to a situation where service is already being provided?
The crisis identification tool is in the record, and I believe the section that was completed when this application was made at the request of this young lady was danger to self or others. Caregiver unable to give care, that usually comes up in the context of a disabled adult who has their parents who may be in advanced age and become physically unable to care for the person. As the appellant points out, there are many, many, many people who want these services.
Well, do you agree with the representation made by opposing counsel that these criteria are disjunctive? In other words, if any of the three apply, then there's an entitlement to crisis?
I think that is true. When you're talking about the 13 waitlist criteria, I don't think any more or less weight is required to be assigned to any one of those.
All right. Well, then if the department can in good conscience challenge a finding that this woman is a danger to herself or others, the further question simply comes to whether or not these services are already being provided.
And the position of the agency is that adequate services are being provided.
Well, where in this final order will we see the finding to that effect? I guess that's what I've been trying to get to.
I think it's implicit in the two references that the hearing officer makes to the fact that this person's being served by the Family Safety Program.
But does the hearing officer find that the services being provided there are consistent with what her needs are?
Again, I think that's putting the cart before the horse. I think you have to have someone eligible for waiver before you look at what their needs are and then deliver the medically necessary services to them under the waiver.
She's eligible for crisis classification if she's a danger to herself or others, isn't she?
Well, Judge, I think she is, but you still have to look at whether or not they're being adequately served elsewhere. A person could be independently wealthy and have caregivers that become unable to give their care, but that doesn't necessarily qualify them for the waiver.
Well, she's already achieved the waiver. She's on the list, isn't she?
Well, she's on the wait list for the waiver. What she seeks now through her representatives is placement on the waiver immediately ahead of everybody else who's also waiting, because the allegation is that she's in crisis.
But doesn't this whole case come down to whether or not these services are now being provided? And your position is that the services are being provided. And Judge, I guess I just still don't understand why simply because she's in foster care that implicitly indicates a finding that the services are being provided.
Again, it's the position of the agency that adequate services are being provided to her. As was adduced in the record, she was in a foster care residential facility at the time of the hearing, Tall Pines Family Center.
That she keeps running away from.
I don't think there was any evidence that she ran away from that facility, Judge. There was evidence that she ran away from prior placements, and I think what the record demonstrates was an increasing amount of services to her through the family safety program. For instance, they moved her from Tallahassee or Leon County to Okaloosa County to the Tall Pines Family Center to give her greater levels of services, or at least placement in a residential service as opposed to the Heidel House or some other place. And as I indicated to you, since the briefs on this matter, she's been placed back with her biological father.
If she's entitled to crisis status under the waiver program, do you agree that she would get more services available to her under that program than is available to her in foster care?
I think she would get different services. As I indicated to you, the services that she would get are under Chapter 393.
Would those different services be more suited to her needs?
Well, I can't say that based on the record, Judge, because when I inquired of Dr. Blandino directly as to whether any part of his evaluation was with respect to developmental disability services or eligibility, he indicated that it was not. Now, he is an expert. We stipulated to that. But I can't say that these particular services sought would be the answer to her problems, if you will. I take it that the answer to her problems may be reunification with her father.
No, there's nothing to the contrary indicating that it would help her more than foster care services, right?
Well, I think, and here I'm running out of time, so I'll ask your leave to answer your question. The issue came up in the hearing as to placement in a particular facility in Orlando called Carlton Palms. The hearing officers in both orders indicated that they can't address a particular placement. And I think that was what was sought through the attempt to adduce the evidence of Tom Shea. And I think that's what was being sought through Ms. Bennett's testimony, is a particular placement. And again, this is an issue of opinion because there are many different stakeholders in this situation. Some of the stakeholders, this child's representatives appointed in the dependency court, believe that these particular services or a particular placement or a particular type of placement is what she needs. The agency, who's charged with administering the Medicaid waiver program, believes that they're not. And what you really are being asked to do is to impermissibly overturn a factual determination, contrary to statute and case law.
Thank you, Mr. Sugar.
Thank you.
Yes, sir.
I wish to address the issue of services. The hearing officer in this case, on page 8, stated the following: there is no dispute that the petitioner requires special medical care. The petitioner participates in the state plan Medicaid program. Now, here's the key sentence from the hearing officer. She states, the hearing officer, the petitioner needs services in excess of those that are provided by the state plan Medicaid. That the petitioner needs services in excess. So the hearing officer in this case found that Amber does require services more than what can be provided by the Medicaid system. Also, the hearing officer makes a very interesting comment about other children who are in foster care and how this affects them. Also on page 8, the hearing officer states the following: once the foster care child turns 18, he or she could be served under the Developmental Disabilities Waiver, as he or she is no longer eligible for the same services and they have aged out of the foster care system. So what the hearing officer stated there was, once these children in foster care who are developmentally delayed and who have psychiatric, psychological problems age out, meaning that once they're 18 years old, no longer in the foster care system, then they can be eligible for a Medicaid waiver. The problem with that is a fundamental problem, that if you're seeking a crisis status based on danger to yourself or others, children like Amber, once they reach 18, might not make it to that age to apply for a Medicaid waiver. I also wish to bring out that the actual...
Counsel, let me ask you a question.
Yes.
On page 8,
Yes.
the hearing officer says, based on the evidence, the hearing officer cannot make such a conclusion as the waiver has medical necessity standards for the utilization of services that are probably not unlike the issues considered by the foster care program in providing services. Is that a finding that the foster care program has services that are sufficient? I was confused by that sentence.
Right. I think that sentence, if I may address it, if we go to the record to page 136 in the record, there's a Marianne Forlazio. Marianne Forlazio was the person who actually made the decision to deny the crisis status for Amber Russell. And Ms. Forlazio states in the record, we don't look at how other programs are serving the individuals. Again, we don't look at how other programs are serving the individuals. Ms. Forlazio simply stated that on the paperwork, she's in the foster care system, therefore she's denied. Because we don't look, we argue at the hearing, well, foster care is not providing the services. And Ms. Forlazio responded, again, we don't look at how other programs are serving individuals. So what we have here is formalism versus substance. The substance of the case is this child is undisputed, not receiving the psychiatric services she needs, the psychological services she needs, the behavioral services she needs. I mean, she ran away at least 8 different times from November 2001 when parental rights were terminated to the date of the hearing. She's been Baker Act 5 different times. She's a habitual runaway. That's what DCF has classified her on the record, as habitual runaway. Kelly Bennett, the guardian ad litem, states very powerfully, she states at the end of her testimony, when asked whether or not that Amber Russell is a danger to herself and others, she states she's going to die. I see my time's up, Your Honor. We're requesting a Medicaid waiver in this case. Thank you.
Okay, thank you both.